Okay, class, we're picking up with Chapter 12, Contracts, and we had left off talking about contractual capacity, and now we're going to talk about the rule with regard to contracts and contractual capacity and minors. Okay, so a minor, of course, is a person under the age of majority, which in most states, including Georgia, is the age of 18. There are other ways in which a person can become a, quote, legal adult even though they're under the age of 18. One of them is to marry. Another is usually to go into the armed services. And the third way is to be emancipated by a court. You go to court and the court determines that you're taking care of yourself, your necessities, and you're on your own, and therefore you can be emancipated. Okay? So emancipation is defined as when a child's parent or legal guardian releases the legal right to exercise control over the child, or is in some cases ordered to do so by a court. Okay, so the general rule on contracts is that a minor can enter into any contract that an adult can, except contracts prohibited by law for minors. The second rule is that a minor's contract is what we call voidable, at the option of the minor, subject to certain exceptions. What does voidable mean? Voidable means that the minor can get out of the contract. Okay, now let's stop there and let's focus on the other party to the contract, which presumably is an adult. The adult cannot get out of the contract that they enter into with a minor. Okay? Alright. So, what happens is the minor, if he or she wants to get out of the contract, does what we call disaffirm the contract. That's the legal avoidance or setting aside of a contractual obligation. The minor has to do this through his express intent or by words or conduct that they're not to be bound by the contract. They have to disaffirm the entire contract, not just part of it. Now, years ago, when this rule was first developing, when a minor disaffirmed the contract was over and the parties stood as they were basically at that time. In modern days, courts have found that to be unfair, and usually the minor is required to return anything that they received as a benefit, that is, consideration from the other party for the contract. Okay, so as I said, only the minor can disaffirm, not the adult. Okay, so before we go into intoxication, let's talk about some of the other rules regarding minors, which apparently I do not have slides on. Okay, so when a minor reaches the age of 18, a contract that he or she entered into prior to turning 18 must be either disaffirmed or after a reasonable period of time it is deemed ratified, and that means that the minor is bound by the contract a reasonable time after they have turned 18. Another rule with regard to minors and contracts is that a minor entering into a contract for a necessity is an exception, and the minor remains liable on the contract, remains responsible for the contractual provisions for providing necessities. So if you got any ideas that you're under 18 and you can go into a fancy restaurant and order a meal for $50, and then when the check comes you can say, sorry, I'm a minor and I'm disaffirming my contract, forget it, that's a necessity and you're bound. Okay, so what are some of the other issues with regard to contractual capacity, which is one of the elements of a valid contract? Intoxication. Intoxication is a condition in which a person's normal capacity to act or think is inhibited by alcohol or some other drug. This type of contract can either be voidable or void. If the person was intoxicated enough that it impaired their mental capacity so that they did not understand what they were entering into, then the contract is voidable. And it doesn't matter whether the intoxication was voluntary or involuntary. However, if the person was able to understand the terms of the contract and entered into it anyway, then it is not voidable. Notice the difference between voidable and void. Void means the contract is not valid regardless. Voidable means that the person who is asserting the invalidity of the contract has the ability to take action to get out from under the contract. Intoxication uses an objective standard as to whether the person's condition was such that they could not understand what they were entering into. Just to review quickly the difference between objective and subjective, objective in the law is almost always basically a reasonable person standard. The law puts itself in the place of, puts the person involved in the contract who's trying to get out of it into an objective standard of how a reasonable person would have been under those circumstances. A subjective contract looks at that particular individual, not a hypothetical reasonable person, but that particular person. So here we're using an objective standard. Mental incompetence is when a person is mentally ill or has some other special disabilities, such as mental retardation, and those contracts can be void, voidable, or valid. It depends upon the circumstances. For example, in Georgia, when a person is incapacitated, somebody else may go to probate court and get a guardianship over them. Okay, there's guardianships over the person and over the property. The person deals with that person's abilities to do certain things. In Georgia, we have a limited guardianship, and it's possible for a probate court to decide that the person can enter into contracts even though they are incapacitated. So this is a sort of individual case-by-case situation with regard to mental competence. Okay. So a party who's not been determined mentally incompetent or has an exception under the probate statute can avoid the contract if at the time of contracting they didn't know they were entering into a contract or they lacked the mental capacity to understand its nature, purposes, and consequences. Only the incompetent person has the option of disaffirming their contractual obligations, or the person who's been appointed their legal guardian can do so as well. So this is just the flip side of what we just discussed. Legality. This is the next type of incapacity to enter into a contract. If the contract is valid and enforceable only if it's legal, has a legal purpose. So a contract entered into to do something that's prohibited by federal, state, or local law is illegal, and it's void. It is not voidable. It is void from the outset and unenforceable. Typical example of this is if you hire a prostitute to perform sexual services and you pay the prostitute and he or she does not perform the services, you're not going to be able to sue because that's an illegal contract. At least in Georgia it is. Okay? Contracts contrary to statute are also voidable or void depending upon the circumstances. A contract to commit a crime, of course, that would also be an unlawful contract. But there are statutes, for example, on usury, charging too much interest. That kind of statute is usually unenforceable. In some situations, based upon the statute, it might be an enforceable contract except as to the interest rate. And that's going to depend on the particular contract and situation. So here we have the usury on this slide. Gambling is another example of illegal and contrary to statute. Licensing statutes, these are interesting.